I should reveal at the outset that I have no magic recommendation that would cure the problem of populism to the extent that we regard it as a problem. And I want to say, I don't think that populism is the only problem facing the human rights system in the world. It may not be the greatest problem facing the human rights system in the world. It may be a particularly challenging problem, as I said yesterday, given that it's occurring in some of the countries that have been most supportive of the human rights system in the world. And if it results in the removal of their support, then for so long as that lasts, the international human rights system is in serious trouble in dealing with other problems as well as the problems of populism. We've seen the difficulty of defining populism. One could stipulate a narrow definition and say, this is what I mean by the term populism. Or one could say that one is focusing on a particular subcategory of populism without making claims about other types of populism. The kind of populism that concerns me today is a form of politics or governance that asserts an exclusionary notion of the people, contrasting the real people with despised elites or minorities or both, and claiming to speak for the popular will, which should not be constrained. I don't offer this as a precise definition, but as a description that shares features with different formulations that are used by political scientists who study populism. This description aims to cover a range of anti-liberal populisms that pose threats to human rights. It deliberately does not include other meanings of the term populism, which might include efforts to achieve political participation for all, or forms of economic populism that seek to make political power depend less on wealth in a pluralist system that respects everyone's rights. Populism of the exclusionary anti-liberal kind threatens human rights in a variety of ways. Most fundamentally, the combination of a narrow definition of the people with the unconstrained implementation of what is claimed to be their will threatens the rights of those in the excluded groups. As for the rights of the included, populism has less predictable effects. It may benefit some rights and impair others, perhaps differently over time. We have heard on previous panels that populist leaders often seek to entrench themselves in office, eliminate rivals, and undermine checks on power. Populism may evolve into authoritarianism. With that definition, should international institutions directly address populism as such? I think there are several reasons why they should not. First, populism is not a legal category recognized in international law, and as we've seen, it has no universally accepted definition. Specifying the contours of populism in the abstract is controversial, and even if the contours were clearer, applying the definition to particular parties or governments would be difficult and very controversial. International bodies would open themselves to charges of bias and political selectivity if they relied on such a concept as a basis for finding violations or condemning states. Second, human rights bodies can focus on the actions of populists rather than their identities. Discriminatory laws, assaults on the independence of the judiciary, suppression of political competition, police violence, and similar products of populism are human rights violations, and human rights bodies can address them without making populism as such the issue. Some human rights bodies have procedures that would enable them to analyze broad patterns of violations, but others would be restricted to a particular subset of violations because of their limited subject matter jurisdiction or the retail nature of their adjudicatory procedure. Third, some forms of populism involve racist or xenophobic incitement that is already regulated by human rights treaties before it produces discriminatory action. For those forms of populism, human rights institutions can address specific populist rhetoric for its content rather than make the label populist the key. Fourth, other forms of populism target groups that lack specific protection in human rights law, such as groups identified as criminals, drug criminals, or globalized elites. I think there is real need for caution here. Human rights bodies can remind politicians that individuals suspected of crimes or convicted of crimes have rights, and they can condemn actual violations of the rights of those individuals. But there is less legitimacy in efforts to censor the rhetoric here, and more danger that such efforts would strengthen public resentment against external intervention. I'm not saying that human rights institutions should ignore the phenomenon of populism. On the contrary, they should be alert to the risks populism creates for human rights and to the special challenges of interacting with populist governments. But they should not try to make populism as such an element of a human rights violation. Turning to other lessons that might be learned, populist rhetoric often includes explicit attacks on international human rights bodies. These bodies are seen as part of the global elite or the world government that threatens the nation. Their decisions are said to favor the rights of criminals, terrorists, migrants, prisoners, and other enemies over the rights of the people. I do not want to make claims of causation regarding the importance of this issue for the success of populists. Multiple factors contribute to the performance of populists in elections and referenda. Nonetheless, I think there is value in examining some of these prominent objections to see whether there are any lessons that could be learned from them. The general claim that human rights treaties result in the peoples being ruled by foreign judges is, to a limited degree, true and inevitable. Countries need to take ownership of their human rights obligations and to recognize them as principles that they have agreed to be guided by for their own protection. In agreeing to transnational adjudication, they are accepting the authority of external institutions to enforce obligations that a current majority may no longer want. That is the purpose of a human rights treaty. They are also accepting the institution's authority to interpret ambiguous provisions differently than a current majority may prefer. Transnational decision-making inherently involves sharing authority with foreign actors. That is a reciprocal benefit that should be defended. More specific claims that human rights bodies overprotect unpopular groups might merely be hateful rhetoric. But examination may sometimes reveal elements of valid concern within them. The fundamental principle of international human rights law is that every human being has rights, and populist movements that seek to deny that principle are essentially rejecting the system. Protection of minorities is one major rationale for human rights law. And yet, protecting the rights of everyone means protecting the rights of non-minority individuals as well. Most human rights are subject to justified limitation for the purpose of directly protecting the rights of others, and also for certain more general purposes that are indirectly related to the rights of others, such as national security. Both the rights and the limitations are important. So then what about the argument that human rights bodies give too much weight to the rights of criminals? Again, claims that people identified as criminals do not deserve to have human rights at all should be repudiated. Others claim that human rights bodies focus exclusively on the rights of criminals. Taken literally, this objection badly mischaracterizes contemporary human rights law. Human rights law places great emphasis on the rights of victims, including victims of private crime. Indeed, some have argued that human rights law goes too far in the opposite direction, of encouraging criminal sanctions for a wide variety of harms. Although human rights bodies rarely lose sight of victims altogether, the greater risk may be that in particular decisions, human rights bodies will strike the wrong balance between competing interests. That question requires a differentiated response. A few human rights are and should be absolute. Torture is the primary example here. The decision to outlaw torture absolutely as a method of investigation is a basic commitment of human rights conventions, and it should not be regarded as treating anyone else's rights as unimportant. But other methods of law enforcement for investigation or prevention may involve rights that are protected in qualified terms. And in those cases, human rights bodies should make clear that they are not disproportionately restricting the government's response to crime. Issues of migration law are another standard populist focus, at least in Europe and some other places, given the xenophobic character of many populist movements. Populists incite hostility to immigrants who are already present in their societies, but also raise fear of uncontrolled future migration. Here it pains me to admit there may be lessons for human rights bodies to learn. The human rights treaties recognize the legitimate authority of states within certain limits to regulate migration. They do not require states to open their labor markets to the world, and they do not require small states to submerge their identity in their larger neighbors. At the same time, migrants are human beings with rights, and the treaties restrict how states treat people within their jurisdiction. In this connection, advocates make some very broad arguments about state obligations to receive migrants, including arguments to multiply the category of absolute non-refoulement obligations, as well as arguments against traditional methods of migration enforcement. Some human rights bodies have taken positions favorable to such arguments. Such bodies also sometimes disparage the importance of state authority to enforce migration controls. One could discuss the lack of support in the treaties for these interpretations, but today I would emphasize how the attitudes expressed and the consequences of adopting these positions may reinforce populist opposition to the human rights system. Other examples that I could talk about, if we had world enough and time, would be the target of UK populists in the extraterritorial application of human rights treaties, particularly in situations of armed conflict, and the famous example of prisoner voting, which became a rallying point for populist agitation against the Strasbourg court. But I won't go into those now. What follows if we conclude that some populist objections to particular decisions of human rights bodies might have some accuracy? Perhaps less than we might hope. There may be some lessons here that would help human rights bodies avoid similar errors in the future and that would not supply new fuel to populist fires. And human rights bodies should be open to reconsideration of their interpretations over time. That does not mean that shifting majorities on a human rights body should reverse existing interpretations without regard to the stability of the system. But I don't claim that changing erroneous interpretations would, as a byproduct, defuse populist concerns and undermine support for populists. No, once populist attacks have been unleashed, their rhetoric usually operates at a level that can gloss over changes in factual reality. Moreover, once populists come to power, they're likely to acquire new reasons for quarreling with human rights bodies. As candidates, they may have appreciated an open political system and their own freedom of expression. But as rulers, they may then seek to entrench their power and deny those opportunities to others. The issues that I have focused on relate to ensuring that human rights bodies can conscientiously deny the populists' accusations. That is valuable, even if it would not be sufficient to defeat unscrupulous opponents in political debate. Thank you.
Thank you. Professor Helfer.
So I first want to thank Jerry and Emily and Dana and other organizers for inviting me to the conference and to think about some of these topics. I have had the good fortune to work with Jerry on a human rights casebook that we both co-authored and have learned an enormous amount from him. And so I hope of some of that learning will be reflected in the summary of my paper that I'm about to present. I came at this, I guess I should say preliminarily, with some skepticism about whether populism was a distinctive challenge for international human rights law institutions. So these institutions very often confront, certainly in different regions of the world at different times, governments that are hostile in various ways to their authority. So there's nothing new about not having a friendly government for an international human rights judge or treaty body member or member of an expert working group to deal with. That comes with the territory. So a question that I had was really, well, is populism different in somehow in terms of a challenge to these institutions? And if it is different, are there any tools or lessons, consistent with the theme of this panel, that they might take away from that? And so what I want to do is divide my remarks into 4 parts. Very briefly, I want to talk about some of the facilitating conditions that I think until recently have sustained the international human rights system, which I think are very much in doubt now, and then talk about several characteristics of populism that might be distinctive in their relationship to international human rights institutions. Third, talk about some of the tools and doctrines that might be deployed, whether by those institutions or by member states that are still supportive of them, in responding to human rights violations of populist regimes. And finally, talk a little bit about survival strategies. And on that final point, I may be a little bit provocative. Particularly, I'm going to engage with some of the discussion of the Latin American panel and my own thoughts on that region, what we heard from this morning. So in terms first of facilitating conditions, just to link to some of the other presentations, Steve talked with us yesterday about the baseline of U.S. human rights policy. Richard this morning mentioned this, if I got it right, structural conditions for populism. So you have to start with some kind of a baseline for assessing whether there has been a change, whether that's due to a rise in populism or some other phenomena. So I think there were a number of facilitating conditions that existed for the most part in the first 50 or 60 years of the international human rights system after World War II, reaching their apogee during the post-Cold War period, and then in the last decade or so beginning to decline. So to really gloss over what is obviously a much more complicated topic, there was, at least at the level of rhetoric, support by a number of powerful states and regional bodies for international human rights norms and international human rights institutions. Those norms and institutions had a kind of general trend line toward increasing their scope, both in terms of the normative articulation of new treaties, of a variety of new institutions and monitoring mechanisms, judicial and quasi-judicial fact-finding and otherwise. And particularly after the end of the Cold War, what seemed to be, at least for a while, a trajectory of improved human rights conditions on the ground. Part of what this facilitating condition, I think there's another characteristic of that as well, which was that many states, even states that were often opposed, were deeply enmeshed in these institutions in ways that limited the ability to push back against the authority of any one of them. So an individual decision could be perceived as out of bounds, but the idea that you could challenge and take on the entire system as a whole was generally, there were real constraints on that. I think that's changed. I don't need to go into the lack of state support. The growth of the system has stalled. At its outer margins, you see lots of debates over whether to expand individual rights and apply them in new ways. You also see a variety of initiatives at the regional and the UN level to strengthen, I'll put that in quotes, international institutions, which really means just the opposite, or arguably to many states means the opposite. And you see true opportunities for disengagement, both at the unilateral level, as Alexandra mentioned this morning with respect to Venezuela, but more generally with respect to the calls for en masse withdrawal from the ICC by African countries, and other kinds of signals, even among stalwart human rights supporters like European governments, to the European Convention to pull back. And Jerry, in his paper, didn't have a chance to go into it, but he does mention, in his remarks, but he does mention how the ECHR has kind of gotten some of the signals from the Brighton Declaration and has pulled back in some areas, and we can discuss whether that's normatively good or not. So the second issue that I want to take up is the populism's distinctive challenges for international human rights institutions, whether there are any. And I'm not going to go back into a definition of populism. I'll share the remarks that Jerry had on that topic, and I just would underscore, in particular, the ways in which the international human rights regime attempts to strike a balance between respect for decisions taken by democratic institutions and the rights of minorities. And you see this concept developed in a number of international human rights systems, but most originally, and probably most in depth in the European human rights system, where you see a real attempt through engaging in detailed balancing to strike some sort of acceptable compromise between, on the one hand, those decisions that are made by democratic institutions that on the whole respect individual rights, but are also considering other societal objectives and broader questions of social welfare on the one hand, and the protection of minorities on the other. And I'm going to bracket, at least for the moment, those human rights norms that are absolute and categorical, because I agree with Jerry there that there isn't any room for balancing with respect to torture, for example. But I want to focus in particular on those situations in which an international human rights institution is asked to review the decision of a domestic body that at least has some claim to a democratic pedigree. And we, Dinah this morning, raised a question about the margin of appreciation doctrine, and there are a variety of doctrines by which these institutions give differing degrees of deference to domestic decision makers who are, particularly when they are part of a democratic system with certain basic requisites in place, checks and balances in government, independent judiciaries, general respect for fundamental rights through constitutions and other legal sources. And in that situation, you see a trend with respect to these close questions of balancing to give some degree of deference to these institutions in this context. And I think that might very well be a distinctive issue with respect to those populist regimes, in particular those regimes where the facade of democratic institutions are maintained, where there is the structure of government, if you look from the outside, looks the same, but in reality the institutions are politically penetrated or hollowed out from the inside, and those opposition institutions that are still nominally in place are cowed into submission or silence. Now, in those kinds of populist regimes, one might imagine that international human rights institutions could respond and say, well, if our democracy is eroding, we ought to narrow our margin of appreciation or, increase our scrutiny of violations, or at least be more suspect with respect to that. And I think that the danger here is that human rights institutions are not going to be able to respond effectively. I think it's worth noting that in many instances, national courts, other sub-state actors, governmental and quasi-governmental as well as private, very often those actors that have been the compliance partners for international human rights bodies, courts, tribunals, treaty bodies, et cetera, may become the source of opposition. We saw that in Venezuela. We saw that, as Alex again mentioned this morning, in the Dominican Republic. So the former allies can become enemies before the international institutions can notice it, or at least they can begin to move away from being allies. Nevertheless, the structures of the doctrines and precedents that are in place to deal with what still seem on their surface to be democratic institutions may not generate the kind of response that would allow for a more nuanced reaction to some of what Jerry refers to as the sort of the actions of populists, even if you're not taking on populism as such, which I, by the way, agree with. So that is one of the distinctive features, right? So that you have a populist regime that still seems on its surface to be somewhat democratic. International institutions have to engage in interest balancing with respect to rights, proportionality review, and the kind of nuanced, fact-specific assessments that they perform may not be at all the kind that populist leaders or populist rhetoric have any kind of patience for, right? So that the kind of differential analysis is going to be, there's going to be, I think, opposition to that. The other area where I think potentially, and I'm not maybe convinced about this, where populism has a distinctive challenge concerns questions of manipulation of social media. So the ability of, we heard about in passing today about some of this in the detailed and very informative presentations with respect to the Philippines and Turkey, that there really are, ways in which the state itself is either controlling from behind the scenes or tacitly encouraging and condoning the keyboard army that is referenced for the Philippines, or the attempts within Turkey's ruling party to essentially manipulate online discussions in ways that facilitate rule by populists. So, and that's an area where I think the limited, or we have a number of doctrines with respect to state responsibility and the affirmative obligations of states that I think may not be well suited for dealing with that kind of situation. So the third point I want to make briefly in my remarks is, are there some specific legal and political tools for countering populism? And I raise three in the paper. I don't, in the end of the day, have a whole lot of hope for them, but I thought I would flag them because I do think there are some recent developments that are worth noting. So one of them is doctrinal, and the example that I draw on is Article 18 of the European Human Rights Convention that prohibits restrictions on rights that are protected in that instrument from being applied for any purpose other than those for which they have been prescribed. And the Grand Chamber, in a judgment against Georgia from late in 2017, amped up the possibility for finding violations of Article 18 in ways that at least some of the judges and certainly a number of commentators have indicated as Article 18 being a new and distinctive tool for addressing the suppression of dissent and the silencing of political opposition that often goes along with the entrenchment of populist regimes. Now, how much value is there in having a bespoke legal doctrine for dealing with populism? I'm not sure. I mean, I think that I share Jerry's concerns about whether this sort of doctrine, even if it is revivified under the new approach of the Grand Chamber, really is a bespoke doctrine for populism, right? It can also be another doctrine to counter authoritarianism or other sorts of repressive regimes. So I'm not sure it's that distinctive, and I do think it also raises the possibility, as Jerry said, of adding fuel to populist fires. Another potential tool, and again, in the interest here of exploring possibilities, would be, whether there are some kind of noncompliance procedures or sanctions that can be taken against populist regimes. And here again, I'll mention another European example, another very current one, with respect to another case brought before the ECHR, an infringement proceeding against Azerbaijan, which not coincidentally also involves an opposition politician and a claimed violation of Article 18. Now, what's going to happen if this proceeding, which was authorized by a 2/3 vote of the member states of the Council of Europe, leads to a finding of infringement? It's hard to say, right? Well, maybe Azerbaijan's votes would be suspended in the Council of Europe. That's happened with Russia to not much effect. Could Azerbaijan be suspended from the Council or pushed out altogether? That's also possible, provided in the statute of the Council. But again, I'm not sure that's a positive outcome. I could say more about the question of whether international norms ought to be changed with respect to state responsibility, with regard to social media companies, but I want to skip that over and talk in my last couple of minutes about potential survival strategies in the age of populism. And here I want to just refer back to some of the discussion of the Latin American, the Inter-American human rights system. And I sketch in the conclusion of my paper, the ways in which that system has been responding over the arc of its history to a wide range of violations. And note in particular how the Inter-American Commission in the 50s and 60s and 70s essentially, went around, to use Tom Fair's colorful language, as a hemispheric grand jury, vacuuming up evidence of high crimes and misdemeanors and marshaling them into bills of indictment that it presented to the OAS and the Court of Public Opinion. Now, nobody expected the governments would change their behavior in the short to medium term, but the Commission did create a factual record that then allowed for, when things changed in the 80s and in the 90s, when the conditions became more supportive, for going back and looking at some of those violations. What I worry about now is that, at least in the Inter-American system, I'm seeing a tendency, unlike in Europe, again as mentioned in Jerry's paper, where the institutions are being still acting like we're living in 1991 or 1999 or whatever the case may be, in the sense that they are reaching to expand norms, creating doctrines like conventionality control, which requires domestic courts and other domestic bodies to apply the convention as interpreted by the Inter-American Court, and bringing in sources of soft law from other regimes through advisory opinions in ways that I think can really add fuel to the populist fires. What I think that risks a real possibility of backlash against the system by governments, both individually and collectively. And it also risks dealing with some of the very core norms and the core problems of human rights that are going to exist with respect to protection of minorities, with respect to opening channels for political dissent, freedom of expression, fair trial rights. There's a whole range of things that are unequivocally within the four corners of any civil and political rights treaty. And when an institution reaches beyond those and creates more expansive doctrines that bring in contestable norms, even norms that I myself might strongly favor, I think you are creating a risk of fanning the populist flames in ways that may get rid of institutions or hobble institutions that may end up being essential for surviving a period of populism. I'll stop there.
Thank you. Before we go to questions, would you like to comment on each other's papers first?
You want me to go first? I have a question for you, Jerry, that I just wonder what you would think. So part of your paper, when you're talking about the shared authority between domestic decision makers and international institutions, right? So you're gesturing in part toward the consent that these institutions have given to international bodies, right? They've agreed to transnational adjudication. They accept external authority to enforce obligations, even in ways that they might differ from how they would be enforced at home. So that leads me to say, well, what if populist leaders say, well, we don't want to share authority anymore? If you're more of a positivist international lawyer and a treaty has a withdrawal clause, that's one way you can take yourself out of that system, and the bargain that you talk about in terms of shared authority eventually disappears. There are many other human rights advocates who'd say, no, you don't want to do that. You don't want to press too hard on consent as being the legitimating, what animates international review, that there's something more fundamental there. And so it's more, I guess you could just take it as a comment, but I'm wondering whether there is a role for, expulsion and sanctions and withdrawal, right, as both, on the one hand, actions that those who support the institutions can take, and on the other, the possibility for a populist regime to say, fine, we don't agree with this bargain anymore, and we're going to put our money where our mouth is and leave.
Thanks for that question. If I wasn't clear, what I meant to be saying about the foreign judges making law was this, that there's a fundamental populist critique, which is our sovereignty means we want to be making all of our decisions, and we don't want foreign judges making law, and that not the job of human rights courts and bodies, by which I mean human rights treaty bodies and similar bodies, but the job of the human rights movement, I think, is to admit that, yes, participating in an international human rights system means accepting constraints on future decision-making that you have chosen to accept, and it means agreeing to shared decision-making for your own good and defending that on the merits as to why it's to the benefit of the state to be part of that. I think that's a good that the human rights movement has to defend to the populations, and that I hope the people would be convinced by. I said I hope that the people would be convinced by. Now, you say, what about consent in terms of withdrawal? We're, for the most part, dealing with international human rights treaties from which one can withdraw. Now, to withdraw from an international human rights treaty, sometimes it's just an isolated thing. It's a treaty. You can withdraw from it. There is no broader consequence but that you've withdrawn from that treaty. Sometimes that treaty is a very fundamental part of a much wider network of international relations with your fellow treaty partners. What would it mean for the United Kingdom to denounce the European Convention on Human Rights while still remaining in the Council of Europe? What would it mean, conversely, for Azerbaijan to denounce the European Convention and still remain within the Council of Europe? I think there's some very interesting political questions about all the forms of cooperation that are contingent politically on that degree of networking and cooperation, as to which the European Convention denunciation clause is not the only thing that needs to be taken into account. But then that gets us to this question about sanctions and withdrawal. Sanctions and expulsion. And here I want to say, I was talking for the most part about human rights bodies, by which I meant these bodies like the regional courts and the human rights treaty bodies, rather than other political bodies that exist in the international system that have a variety of responsibilities, but which include human rights responsibilities. And they have much more in the way of political discretion, much more in the way of easily defended selectivity in responding case by case to problems as they arise. And the kinds of constraints that make me say populism as such should not be the explicit focus of a human rights body don't apply in the same way to what are the decisions that the political bodies are going to make about different countries within their system of cooperation. Which is not to say that one should hurry to expel a populist country. It's a very complicated question as to when things become so bad that you no longer want this country to be part of the system of cooperation. You have to also ask questions as to what are you now saying? Are you saying this country should no longer be part of your system of cooperation and therefore will no longer be part of any functioning human rights system? Or that you have some human rights system which is a much higher level of values as to which, no, they're no longer qualified to be a member, and they should be part of some of the other broader ones that they're also a member of. I think those are, very interesting and complicated decisions. But those are decisions that the relevant bodies would have to face, could not be easily decided, even if they could be decided. And then we have to recognize the possibility that these political bodies may actually not even have the ability to decide them, because in some cases we may be dealing with systems that have multiple candidates for expulsion who are then in a position to join together and block any sanctions against each other. So that might not even be a decision that needs to be contemplated. That's how I'd respond to that. And rather than try to return with a question regarding your own talk, I'll say I would be much more interested in hearing what other people in the room have to say than hearing what I have to say.
Great. Thank you. Okay, we can start over here with Alex.
Wait.
I have two questions. One is for Larry. So I'm wondering if in hearkening back to this article you mentioned about the commission and how it was this sort of grand jury for the region, that was a time before the Inter-American system had really become judicialized in the way it became in the 90s. So it was before the individual petition became the focus of the commission. So I'm wondering if in looking forward to a time, which I don't think is now, right? I don't think populism now has spread throughout Latin America, and that's the time we're talking about. But if there came to be a moment in which there was some sort of necessity for a retreat such as the one, and maybe you think that's already the case, in which the court becomes more legalistic. I wonder if there wouldn't be an opportunity for the commission, since the Inter-American system has this dual modality, to have a different approach, right? To have a less legalistic and more political and perhaps open-ended approach. And my other question is whether for both of you, whether you think corruption is something that the human rights systems could or should approach.
So should we answer for each question?
Yeah.
So on your first point, so I hadn't envisioned the commission going back to its role in the early days of the system as such. But you are right to point out that it does have a broader mandate. It does do, fact-finding and country visits and a variety of other things, which I think are, important functions, right? Because it allows for taking on a different cut at an issue that, an individual petition presents a set of facts and a particular set of litigants and doesn't always let you see the bigger scenario. Sometimes that's good because you can focus on the individual and the particular remedies as emblematic of the problem in a particular country or type of legal system, but other times not. I don't think the commission is ever going to give up that petition process. They are, after all, the gatekeeper for the court, and as long as that exists, then they're always going to have that kind of role. I think what I'm more envisioning is, I have to think about how it gets actually operationalized on the ground. And it might be a rebalancing between the petition function and not. I mean, one could imagine, and I'm not sure I want the commission to play this role, but one could imagine the commission being a screener in a way that if they're attuned to what I'm suggesting, they can be more cautious about which cases they actually send to the court. One could imagine that being part of their role as well. So I have to think more about precisely what it looks like, but no, I don't see them going back to the past. And your second question was? Corruption. Oh, corruption. We were having an interesting exchange last night about this, and I actually think, given the way, I'm curious to hear what Jerry has to say, the current system is structured, a well thought through case that linked human rights and corruption, and linked it in particular to the InterAmerican Convention on Combating Corruption, the UN Convention, could gain traction. And maybe that would actually be, an example of an expansion where, I feel differently than I do about some of the other ones. But
on the subject of corruption, I want to say a few differentiated things. First is the question of, do we expect there to be judicial decisions in which some individual says, I'm damaged by corruption? And how exactly are you damaged by the corruption? And what can you prove about how you're damaged by the corruption? But that's not the only way that human rights oversight takes place. When I was on the Human Rights Committee, enforcing the Covenant on Civil and Political Rights, the Human Rights Committee at that time was taking the view that judicial corruption, police corruption, corruption in prisons, that these are all issues that are directly linked to rights under the Covenant, as to which the fair trial rights, conditions of detention rights, and so forth, as to which monitoring occurred, and we did. There was more of a hesitancy to deal with legislative corruption as not closely enough linked, although one can understand how one might say the right to political participation is undercut by legislative corruption. Or one could talk about rights of various kinds for which resources are needed, which are not really being fulfilled. States are not fulfilling their positive obligation to protect people against crime because the money's being spent on building palaces and swimming pools. But those arguments weren't being made at the time. I think on the Human Rights Committee, they actually are now expanding more generally into the question of monitoring the issue of how corruption is being dealt with. I think it's easier, in a sense, or it just felt easier, for the Committee on Economic, Social, and Cultural Rights to deal with the question of corruption. Corruption is the diversion of large parts of the budget, and budgetary analysis is becoming a tool of economic and social rights monitoring. So I think there are ways of not necessarily identifying corruption per se as a human rights violation, but including corruption in the gravitational field of human rights monitoring, so as to put a spotlight on corruption. And then there's also the question of whether one should just come right out and recognize corruption in general as a human rights violation in relation to some of these other rights as I've described, in the way in which it was always clear that corruption in a fair trial, or police who arrest people because you have to bribe the police not to be arrested, that this is just a human rights violation of corruption.
Okay. We're going to start with Dinah, and then we'll go to Jeremy after that.
Okay. I have two questions that flow from the topic of lessons learned. The InterAmerican system has the two smallest human rights bodies of any in the world. There are only 7 commissioners and there are 7 judges. And that means that one method by which populist governments could influence the system is by nominating and vote trading to elect particular people as commissioners or judges. And I mention this in the context of your your suggestion about conventionality control being something that provokes a backlash, because it's the baby of a particular judge, and he pushed it when he was on the court. And with him gone, I think that that doctrine is going to lessen in importance, if not disappear altogether. That happened with jus cogens, when one of the former presidents pushed that during his tenure, and it went away when he left. It has hardly been mentioned since then. So my question is, what do you think about vote trading and the nomination process to the court and the commission? My other question stems from Jerry's reference to political bodies. In the European system, one of the most pro-human rights bodies has been the Parliamentary Assembly, and it has often gone ahead of the court and ahead of the Committee of Ministers. Again, populist governments could play off political bodies against each other. The Committee of Ministers against the Parliamentary Assembly, the court against both of them. So what do you think about that possibility?
Can we get Jeremy's question just in the interest of time, collect questions, and then?
Yeah, different matter, I prefer.
Oh, okay, sure.
So I don't know, Dinah, what are the requirements, if any, at the micro level for qualifications to appointments to commissions in the court. I agree with you, it's a big problem. And I think it's an area that states have started to capitalize on, but maybe have not as fully capitalized on. I think how successful that will be, you're right, when you have a smaller body, it's easier to get capture. Compare 7 to 47 judges, right? And the mechanisms for appointment and election and nomination are, ripe. In some systems can be manipulated and abused. And I think it hasn't happened as much. And I just want to kind of gesture back to kind of Alex's point in her remarks about how some of the populist regimes in Latin America have used international human rights norms or invoked international human rights arguments. I think that makes it even more of a concern when a populist-inflected human rights judge can be appointed where the trappings of human rights norms are there, but in fact, one can be skeptical of how committed they are to the text and its prior interpretation. So I'm not giving you a long answer, but I think you put your finger on something. I almost wish you hadn't raised it, because if somebody hears it, right, of course, the judges, we should have. But I think that's a significant one. I'll leave the other question to Jerry.
Gee, I was so focused on the vote trading.
You can respond on that too.
Did I forgotten what the other question was?
It was about playing the political bodies and the human rights bodies off against each other.
I think all I can say is yes. There's human rights. Human rights is morality, law, and politics. And it takes place in these fields, and states have agreed to participate in it while putting it in these fields. And there is an interaction among all of these different possibilities, and they have opened the possibility for civil society to be involved in the system, and civil society, national civil society and global civil society have to be involved in critiquing the way states use the system. So if it's being abused, it has to be criticized. There are strengths to having political bodies involved. The fact that political bodies are involved in the enforcement of the judgments of the European Court of Human Rights is beneficial. But what can be beneficial can also be detrimental, and eternal vigilance is the price of liberty.
I think this is for Laurence. You spoke very sensibly about the need for some respect for the decisions of majoritarian institutions while at the same time paying attention to the rights of minorities. I wanted just to add to that a plea for some clarity about the logic of majorities and minorities. Now, courts decide by majority decision, legislatures decide by majority decision, plebiscites decide by majority decision. In every such decision, whatever the outcome, there's going to be a decisional majority and a decisional minority on the court, in the parliament, in the plebiscite. And nothing oppressive, no rights are violated merely from the fact that a particular person or group loses the vote. What we ought to be interested in is not decisional minorities, but topical minorities, those whose rights or interests are at stake. And those topical minorities, they may have their interests guaranteed better by legislatures than by courts, or by courts and by legislatures on any particular time. So it's just a plea not to think that there's anything inherent about majoritarianism, which is opposed to human rights. We have to keep clear about the distinction between decisional majorities, decisional minorities, topical majorities, topical minorities. We're worried when those two sets of categories line up together. But in most cases they don't, and certainly in the decisions of courts they don't. Nothing bad happened to Justice Scalia's rights as a result of being in the minority on a Obergefell and Hodge.
Yeah, I take that as a clarifying, friendly amendment, and I entirely agree with it. So thank you for being more precise than I was.
Okay. Wojciech?
So I would like, somewhat polemically, perhaps with Jerry, about your skepticism on whether international human rights, especially judicial bodies, should or shouldn't address populism as such. And it seems to me that one has to distinguish between two situations. One situation is that of a populist state. And probably there's very little room for the European Court of Human Rights to openly find breach in state actions on the basis of its populism. But a different second situation in which populism may enter or figure in the argument of the court is when the member state wants to actually restrain or regulate populist movements inside this, that state. And in this case, I think that there is certainly room for, say, talking about European Court of Human Rights, to apply the doctrine of militant democracy. And that is what the ECHR actually did. And in this way, I would like perhaps to shift to Professor Helfer. When you mentioned various judicial doctrines at the international level, you haven't mentioned, and in a sense, no one mentioned so far in this conference, an idea of militant democracy. Now it figured prominently in some ECHR's decisions, especially Refa Partisi. Of course, Refa Partisi judgment is very, very controversial, and many people consider it to be very bad judgment. Some people consider it very good judgment. Sami Zakharov, in his Fragile Democracies, gives it as an emblematic way in which international human rights may actually pair with an internal body in a member state, in this case, Constitutional Court of Turkey, to address the problem which they saw of the emerging populist movement. Perhaps with the benefit of hindsight, we now see that it was probably an unwise decision, and there were many dissenting opinions. But at that time, it was, I think, perfectly legitimate. So it seems to me that there are ways for the international human bodies, in a sense, to use, I think, your formula from your great classical article on supranational adjudication, to pierce the veil of the state and to somehow enter into coalition or alliance with one body against other, including in its struggle against emerging dangerous populist movements.
With regard to militant democracy, I simply I simply would say that the word populism doesn't, to my recollection, figure in any of the decisions of the European Court applying Article 17, and that the concept has to do with assaults on the rights of others, and that one can do the analysis of whether or not to uphold the state's decision to ban a party which is committed to the destruction of the rights of others based on the demonstration of the party's program for destroying the parts of others. And I think that's consistent with what I was saying human rights bodies should do. That populism as such doesn't have to, should not be the element in the analysis, perhaps doesn't even need to figure in the analysis, although maybe what you're suggesting is that when the court decides whether the restriction is necessary or proportionate, that it may analyze the situation, including awareness and explicitly mentioning that we're dealing with a populist party. But the problem still is not that the party is populist. The problem is that the party is aiming at the destruction of the rights of others. That's how I'd respond.
So you raise a very interesting point, and I hadn't thought about the way in which international bodies might, in the way that's been described by a number of people, form alliances to build a system over time, incrementally, through connections to national judges, minority parties, administrative agencies, NHRIs, what have you. What you're describing is in some way that there can be, in a time when there's an erosion of democracy toward populism, alliances between the remaining independent institutions and the international body that can maybe backstop that independent body and give it some additional force in its dealings with, the political leadership. So it's an intriguing idea. I wonder whether the ability of international decision makers, judges, committee members, whatever, to be able to precisely identify which institution that should be. Imagine if you break out a national judicial system, as your paper shows, there are different ways in which the system was disassembled, I'm not sure that's the best word. So some of those entities remained independent longer than others. And in principle, there could be some kind of relationship there. I also worried about the time lag between decisions that are taken at the domestic level and then when an international decision is taken several years later, that institution may be gone. So I worry about both the ability of international decision makers to accurately discern who their partners should be in this destabilizing time, and I worry about, even if they can do that accurately, whether by the time they do act, it's already too late.
That's all we have the time for. We're going to take a quick break. I encourage you to continue to have these conversations during the break, and then we'll come back at 2:45. Please join me in thanking Professor Neuman and Professor Helfer.